Imagine you've lived in this country for years. You work hard, you pay your bills. You never thought twice about your status because nothing major seemed to be changing. And then one day, out of nowhere, you get detained at a traffic stop. Or you try to fly home from a trip abroad and you can't get back in. Or you go to renew your work permit and the rules are completely different from what they were just 6 months ago. This is not a hypothetical anymore. This is happening to real people right now in 2026. And if you are not paying attention to what has just been approved and signed into law, you could be the next person caught completely off guard. And before I walk you through exactly what changed and what it means for you, do me a quick favor right now. Hit that subscribe button, because this channel is where I break down every single immigration update, policy change, and new law in plain, simple language before it becomes a problem at your door. These are not slow changes. They are happening fast, and the next video I post could be the one that saves your status, your job, or your family. Subscribe now so you never miss it. Okay, so here is what you need to understand. The United States immigration system in 2026 looks very different from what it looked like just 1 year ago. We are talking about new laws signed by Congress, new executive orders, new agency rules, and new enforcement actions that are reshaping who can come in, who can stay, and what happens to people who are already here. This is not panic. This is preparation, and the people who stay informed are the ones who stay protected. By the end of this video, you are going to know exactly what the biggest changes are, how they could affect you personally, and what specific steps you should take right now. Whether you have a green card, a work visa, a pending application, or you are living here without status, there is something in this video that directly applies to your life. So let us get into it. Let us start with the law that changed everything when it comes to enforcement. It is called the Laken-Riley Act, and it became one of the very first laws President Trump signed in his second term. It is now public law, which means it is not just a policy that can be reversed with a phone call. It is written into the books. Here is what it does. If you are in this country without authorization and you get arrested or charged with certain crimes, you will now face mandatory ICE detention. And I mean mandatory. The judge cannot let you go. ICE cannot release you on bond. You will be held while the government moves forward with removal proceedings. Now here is the part that most people are not thinking about. The list of crimes that trigger this detention is not just murder or assault. We are talking about shoplifting, theft, burglary, an altercation that gets charged as assault. You do not even have to be convicted of anything. If you are arrested and charged, that is enough. Think about that for a second. A minor dispute that gets escalated, a misunderstanding at a store. These things used to end with a fine and a court date. Under this new law, they can now become an immigration emergency that fast-tracks you toward deportation. And the enforcement numbers back this up. ICE was arresting an average of 746 people every single day from January through October of 2025. As of February 2026, more than 68,000 people were sitting in ICE detention centers across the country, and the government has removed over 675,000 people from the United States. These are not just numbers. These are people with families, jobs, and lives that were upended. The machinery of enforcement is running at a speed this country has not seen in decades. So what does this mean for you personally? It means that if you are undocumented or have any kind of uncertain immigration status, you need to be incredibly careful about any situation that could lead to police contact. You cannot afford to assume things will work themselves out. And if you have family members in that situation, talk to them. The consequences of a small mistake right now are much bigger than they used to be. There is also something called the alien registration requirement that has been in the news. Under a law called INA Section 262, any non-citizen who is in the United States for more than 30 days is legally required to register with the government. The deadline that was set for people who were already here was April 11, 2025. If you missed that, or you came after that date and did not register, you are at risk. Failure to register can lead to misdemeanor charges, fines, and it gives immigration authorities another reason to target you. This is a real, active requirement right now, not something that is still being discussed. Now here is where it gets even more serious for people who travel internationally. The travel restrictions that have been put in place are sweeping. A presidential proclamation that took effect January 1st of 2026 expanded travel bans to cover nationals from 39 different countries. For 19 of those countries, including Afghanistan, Iran, Syria, Yemen, Eritrea, Haiti, and several others, there is a full suspension of entry. That means both immigrant and non-immigrant visas are affected. If you are from one of those countries, you may not be able to get a visa at all right now, even if you have family here, even if you have a job offer waiting. But here is what makes this even more complicated and what a lot of people are missing. The restrictions are not only based on your passport, they are also based on where you were born, whether you have dual nationality, your prior long-term residence in certain countries, and your recent travel history. So even if your passport is from a country that is not on the list, if you were born in one of the affected countries, or if you lived there for an extended period, you could face extra scrutiny at the consulate or at the port of entry. This has already been causing delays and surprises for people who thought they were in the clear. On top of that, visa issuance has been paused for people born in at least 75 countries, and nationals from a second tier of about 20 additional countries are facing partial restrictions, reduced visa validity, and enhanced vetting. This is creating enormous unpredictability for anyone planning international travel, anyone waiting on a visa, or any employer whose workers need to travel and return. Quick question: are you subscribed yet? Because here's the thing. Most people who watch this video will forget about it in a day or two, but if you subscribe, you will get reminders every time something new comes up that could affect your status, your travel, or your family. These changes are moving fast and they are not slowing down. It takes 2 seconds. Just tap that subscribe button right now. Now let us talk about the law that is reshaping immigration in the most comprehensive way we have seen in years. It is called the One Big Beautiful Bill Act, and it was signed into law on July 4th, 2025. This is not an executive order. This is actual legislation passed by Congress and signed by the president. It is now federal law, and it poured roughly $170 billion into immigration and border enforcement. That money is going to more detention beds, more border wall construction, more funding for ICE and customs and border protection, and resources to speed up deportation proceedings. But the part that hits the hardest for many immigrants is what it does to the asylum system. For decades, applying for asylum in the United States was free. That is now gone. The law creates a filing fee for asylum applications. This might not sound like a huge deal until you realize that most people who apply for asylum are already in desperate situations. They fled violence or persecution. They do not have a lot of money saved up. Putting a price tag on protection changes who can realistically access it, and the fee cannot simply be waived because it is written directly into the statute. It is not a regulatory choice. It is the law. The same bill also created something called the annual asylum fee for employers who use certain work visas. So if a company hires workers on H-1B or similar visas, they may now owe a fee specifically earmarked for enforcement, not for processing those applications or helping workers get their status. It is essentially a tax on legal immigration being used to fund the crackdown on illegal immigration. And some portions of this are already being challenged in court, though the core of the law is very much in effect. Beyond the fees, the One Big Beautiful Bill Act also massively expanded detention capacity, and it removed prior limits on detaining children and families. That is a significant shift from where things stood even a few years ago. The infrastructure for enforcement has grown, the legal authority has expanded, and the funding is now there to sustain it. Let me pause here for just a moment. If this information is already helping you understand what is happening, imagine getting updates like this every single day. That is exactly what subscribers to this channel get. Clear, simple, no-nonsense breakdowns of everything that matters for your immigration situation. Tap that subscribe button now so you never miss a critical update. Now here is something that a lot of green card holders did not see coming, and it is important. Starting March 1st, 2026, the Small Business Administration changed its rules for who can qualify for SBA-backed loans. The new rule is this: only businesses owned entirely by U.S. citizens or U.S. nationals can get those loans. That means if you are a lawful permanent resident, a green card holder, you are now excluded from owning any percentage of a business that applies for an SBA loan. Not just a majority, not just more than half, any percentage at all. This is a major change for immigrant entrepreneurs. SBA loans are one of the primary ways small business owners get financing in this country. Green card holders have been eligible for these loans for a long time, and now, as of March 1st, 2026, that door is closed. If you own a business and have a green card, or if you are a partner in a business with someone who has a green card, you need to review your current situation immediately because this could affect any pending or future loan applications. There is also a change that affects every single non-citizen who travels internationally, including green card holders. A new rule that took effect December 26, 2025, expanded the government's biometric entry and exit program. What that means in practice is this. When you enter or leave the United States at any airport, landport, seaport, or other authorized crossing, Customs and Border Protection now has the authority to collect your facial biometrics. Your face is scanned. That data is linked to your travel history, your visa records, and everything CBP has on file about you. If there are any discrepancies, if something does not match up between your documents and their databases, you can be sent to secondary inspection. You could face delays. And for people who have recently changed their status, renewed a visa, or have any pending applications, the concern is real. Your records may not have fully updated across all the government systems yet, and that lag could cause problems at the border. The advice here is simple. Before you travel internationally, make sure all your documents are current, consistent, and accurate. And for refugees specifically, there is a memo that was quietly issued in February of 2026 that has some very serious implications. Under this DHS policy, refugees who have been in the United States for 1 year are required to report back to the government for a review as part of their green card process. That is not new, but what is new is what happens if they do not show up. Under the old rules going back to 2010, simply not getting a green card was not enough of a reason to detain a refugee. That protection has been formally canceled. If a refugee does not report for their review, DHS can now arrest and detain them for as long as that review takes. This is a real change that affects thousands of families. Before I continue, I need to say something directly to you. The people who stay updated on these changes are the ones who avoid problems before they happen. If you are not subscribed to this channel, you are relying on luck. And in 2026, luck is not a strategy. Hit subscribe right now and join thousands of people who stay ahead instead of playing catch-up. There is no cost. It just takes a second. Now let us talk about something that is catching a lot of visa holders by surprise. If you are on an H-1B work visa or you are a dependent on an H-4 visa, there is a new requirement you need to know about. The State Department expanded what it calls online presence review to include H-1B workers and H-4 dependents. What this means is that when you apply for or renew your visa, you are now required to disclose your social media handles and profiles. And here is the critical part. Your accounts need to be set to public during the time your application is being reviewed. Most people's first instinct is to think, okay, I will just delete my accounts or make them private. Do not do that. Government guidance specifically says that removing content or deactivating accounts will not protect you from scrutiny. In fact, doing that could raise more red flags. What you need is consistency. Your online presence, your professional profiles, your posts need to match what is on your application and your resume. If there are inconsistencies, that is where problems start. At the same time, USCIS reduced the maximum validity period for employment authorization documents, which is the work permit, from 24 months down to 18 months. That might seem like a small detail, but it means you will be renewing more often. And every renewal is a window where a delay or a problem could leave you without work authorization temporarily. This is especially risky if you are on a status that requires an active EAD to maintain employment. And for DACA recipients, the situation remains very uncertain. Courts have found that the DACA program was created without full legal authority, and the case is still working its way through the appeals process. Right now, USCIS is only processing renewals for people already in the program. New applications are not being accepted. On top of that, a new HUD rule from March 2025 restricts FHA-insured mortgages to U.S. citizens and lawful permanent residents, explicitly excluding most non-permanent residents, including many H-1B workers and DACA recipients. If you were planning to buy a home using an FHA loan, this change affects you directly. So here's what you should actually do right now, today. First, check your registration status. If you are a non-citizen who has been in the United States for more than 30 days and you have not registered under the alien registration requirement, get that done through your MyUSCIS account as soon as possible. The deadline may have passed, but compliance now is far better than waiting and being found non-compliant later. Second, if you hold a green card or any kind of work visa, review your travel plans carefully before you leave the country. Check that your passport, your visa documents, and your records with CBP are all consistent and up to date. Build extra time into your travel schedule because delays at ports of entry are happening more frequently. And if you are from one of the countries listed in the travel ban, or if you were born in one of those countries, speak with an immigration attorney before you travel internationally at all. Third, if your EAD is coming up for renewal, start that process early. Do not wait until you are 2 or 3 months out. Start 6 months ahead. Processing times are longer now, and the consequences of a gap in your work authorization can affect your employment, your income, and your status all at once. Fourth, if you own or are part of a business and you hold a green card, review your relationship to any SBA-backed loans or pending loan applications. Talk to a business attorney or an immigration attorney about how the new SBA rule affects your specific ownership structure. This is not something you want to discover after you have already submitted an application. And finally, do not rely on secondhand information. Do not trust what someone told you at work, or what you read in a social media comment, or what a friend of a friend said happened to them. Immigration law right now is changing faster than at any other point in recent memory. What was true 6 months ago may not be true today. Always verify through official government websites like usis.gov, dhs.gov, and travel.state.gov, or through a licensed immigration attorney who is actively following these changes. Here is the reality. What is happening right now is not just a stricter version of the immigration system you already knew. It is a fundamentally different system with new laws, new fees, new detention rules, new vetting requirements, and new restrictions that touch every part of the process. From the moment you apply for something, to the moment you travel, to what happens if you get arrested for something minor, the rules have changed in ways that can have life-altering consequences. The people who are going to come through this period okay are the ones who treat their immigration status with the same seriousness that a business treats a contract or a homeowner treats a mortgage. You have to stay informed, stay documented, and stay proactive. You cannot wait for a problem to show up before you start paying attention. By then, it is often too late to fix it cleanly. And I want to be clear about something. This is not about fear. This is not about telling you that everything is falling apart. It is about giving you the information you need to make smart decisions for yourself and your family. Knowledge protects you. Ignorance, unfortunately, does not. And now that you know what is changing, you know what to do. If this video helped you understand what is happening and what to do about it, make sure you are subscribed so you catch the next one. I will be covering more updates that directly affect your status, your travel, your work authorization, and your family. And if you know someone who needs to hear this, send it to them right now. It could make a real difference in their life. Thanks for watching, and I will see you in the next update.